All right, everyone, let's go ahead and get started. It's now 2 p.m. This is the State Expedited Accusations calendar. I'm Judge Melanie Williams. This is the State Court of Fulton County, and today is January the 6th of 2023. This calendar is for those individuals who've been recently arrested, but the Solicitor General has already formally accused these cases and bound over. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. All participants, this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this proceeding. All right. Are there any other, as all the members of the Public Defender's Office had opportunities to interview their clients?
I've been able to interview everyone except a Miss Shanta Robinson.
Okay. Is she at South Annex, I'm assuming? Perhaps when South Annex comes on the line, you can give the jail a call, Ms. Thomas.
Thank you.
Ms. Gant, have you had the opportunity to interview everyone?
Yes, Your Honor.
All right. Good afternoon.
Your Honor, good afternoon.
Good afternoon, Ms. Sillette.
I just wanted to inform the court that I'm going to be the only ASG on today. So if everyone could just bear with me. And I know Ms. Robinson was a behavioral reset on yesterday. So there may be some sort of issue like that today as well. Just wanted to inform the court of that.
Okay. All right. All right. That said, let's begin. Who do we have first at courtroom 2?
Good afternoon, Judge. This is going to be position number 5, Mondragon.
All right. Good afternoon, Mr. Mondragon. Your case is 23 CR 000069A. In this case, you're charged with battery family violence with the offense date of January the 5th. Do you understand your rights?
Yes, ma'am.
All right. Who do we have from pretrial today? Oh, I see Ms. Bostic. Ms. Bostic, can I have the history, please?
Judge, in regards to Mr. Mondragon, 2 prior arrests, conviction was 02, possession of meth.
All right, thank you. All right, Ms. Sillette, please proceed.
Yes, Your Honor. On yesterday, January 5th, 2023, officers were dispatched to 2967 Metropolitan Parkway in reference to a domestic dispute. Upon arrival, officers spoke with the victim in this case, Mr. John McGahee, and McGahee is spelled McGehee. The victim stated that he and the defendant had been roommates for about a month. And shortly before police arrived, he and the defendant had gotten into a verbal argument. After the argument, Mr. McGee went into his bedroom and sat on his bed. At that time, the defendant entered the bedroom and forcibly grabbed both of Mr. McGahee's arms and pinned him down to the bed. This action caused the victim to have severe bruising to both of his forearms. He also had a small laceration on his left hand and minor bruising to his chest as well. His injuries were photographed. Officers did note that the defendant appeared to be under the influence of some sort of narcotic, as he was making erratic and unintelligible statements. He was also making statements about officers to be careful, and he was anxiously looking back and forth. He was arrested at that time. The state also saw a obstruction, hit and run, and battery arrest from October of 2022. That case has since been transferred to Superior Court, but the state court case number was 22 CR 0070707A. And Judge Law did order a $6,000 signature bond on that case. She also ordered him to have no drugs, alcohol, or weapons while out on bond. The facts in that case allege that the defendant did intentionally strike someone with his vehicle. It's a different victim in that case, but the state does have concerns about him being out on bond on those charges and now picking up another violent arrest. So the state would argue that he does pose a risk of reoffending in the future, and he is a danger to the community and others. The state's recommendation at this time is going to be $7,500 surety bond, no contact with the victim, no alcohol, drugs, or weapons, stay away from the incident location, and an alcohol drug evaluation. Nothing further from the state at this time.
All right, thank you. Ms. Thomas?
Thank you, Your Honor. Your Honor, Mr. Mondragon has been a Georgia resident for the past 2 years. Mr. Mondragon does have a wife and 4 children residing in the state. He has 3 daughters and 1 son. As we heard, Mr. Mondragon was a roommate for Mr. McGehee. He's been renting there, and he stated to me that Mr. McGehee is an elderly man that he had been helping at the time. We are denying the allegations currently. Mr. Mondragon does not recall this incident. However, he did express that he does not have issue with finding somewhere else to go. So we are unopposed to a stay away and no further contact at this time. Mr. Mondragon did express that he did lose his cell phone in the past 2 days, so he does not have the ability, is unsure if he'll have the ability to make bond. So I am asking for a bond amount if he's ineligible for a signature bond, given the recent case. For a bond, I'm asking for a bond no more than $1,000 at this present time.
I'm gonna sound for Mr. McGehee or McGahee at this time. All right, hearing none. Defendant will receive a $2,500 surety bond. He's to have no contact with the alleged victim, last name McGahee, and stay away from the incident location on Metropolitan Parkway. Have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further. Thank you, Your Honor.
All right, best of luck to you, Mr. Mondragon. Who do we have next?
Position 10,
Have a good
Williams.
one. Thank you, sir. Thank you, ma'am.
I'm sorry, did you say position 10?
Yeah, position 10, Williams.
All right. All right, good afternoon, Mr. Williams. Your case is 23 CR 00070C. In this case, you're charged with battery of family violence with the offense date of June the 30th of 2022. And you're also charged with simple battery of family violence. Do you understand your rights?
Yes, ma'am.
All right, and as a reminder, those who receive a surety bond today will be reset to the state all purpose on January the 20th, whereby bond and other conditions can be revisited. All right, Ms. Bostic, can I have the history, please?
Judge, in regards to Quan Williams, 2 prior arrests, no prior convictions.
All right, thank you. Ms. Salette.
Yes, Your Honor. On July 1st, 2022, officers were dispatched to 2050 Bent Creek Way in reference to a domestic dispute. Upon arrival, contact was made with the victim, Miss Denia Williams. That's spelled DYNIA. Stated that she was assaulted by her boyfriend. Miss Dorothy Porter, who is the victim's mother, was also present during the incident and stated that she witnessed the victim being assaulted as well. Miss Williams stated that early in that evening, Miss Porter gave her permission to drive her vehicle. And then later on in the evening, the defendant advised that he wanted to borrow the car as well. The victim told him no, he couldn't borrow her mother's car, and that she needed to get the car back to her mother at that time. The defendant became upset, and the two began to tussle over the keys. And at that time, the defendant pulled the victim's hair, causing it to rip out of her head. And the defendant then took the car keys, left the location, and didn't come back with the car. And Ms. Porter, the owner of the vehicle, showed the registration to officers and let them know that she did not consent to the defendant taking the car. There were no warrants taken out for the theft by taking. I'm not sure why. So our office will be reviewing this case in the future for felony transfer. Due to the nature of the charges, this being a family violence incident and what we know about the cycle of violence, the state would argue that the defendant does pose a risk of reoffending. The state's recommendation at this time is going to be a $7,500 surety bond, $5,000 for the battery, $2,500 for the simple battery. no alcohol, drugs, or weapons while out on bond, no contact with the victim and witness, the victim, Miss Williams, that witness, Miss Porter, stay away from that incident location, and a 1-day anger awareness. Nothing further at this time.
All right, I'm sounding for Miss Denia Williams at this time. All right, hearing none, Ms. Thomas.
Yes, I'm trying to turn it on. I don't know how to turn the mic or the camera on. I was able to get the mic working, but I can't get the camera to work. It keeps saying unable to access camera.
You have to turn it on. Keep trying. In the meantime, we'll hear from Ms. Thomas. Ms.
Yes.
Thomas, please go ahead.
Thank you, Your Honor. Mr. Williams is 22 years of age. Mr. Williams is a Georgia resident. He and Miss Williams, Miss Denia Williams, do reside together. They share 2 children together. Mr. Williams did express that he does not have any other family here residing here in Georgia. Currently, Mr. Williams is a current student at Atlanta Tech. He's a high school graduate as well. He expressed that he does not reside with Mrs. Williams' mother, the other Mrs. Williams. I don't believe I heard any history pertaining to Mr. Williams, especially no violent history and no domestic history, Your Honor. I am asking for a signature bond. I did also have the chance to speak with Ms. Denia Williams, who also denies the allegations and stated to me that this was a misunderstanding, that she did not call the authorities and did not wish to press charges. She also stated that she had contacted the solicitor's office to express those same sentiments. Given that Mr. Williams, again, is currently unemployed, doesn't have any history, and is a current student, I am asking for a signature bond that he be allowed to have contact with Ms. Williams, since they do share 2 small children, and that he be allowed to return back to their residence.
All right, Ms. Williams, have you been able to get your camera on? I don't even see her on the screen. Okay, there
She's
she
logging
is.
again now, Your Honor.
I see her coming. Ms. Williams, you must be able to turn on your camera so that we can identify you. Are you
Okay,
able to turn the camera on?
Yes,
Okay,
I was
there
able
you
to
are.
turn it on.
All right, please raise your right hand if you'd like to make a statement. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell the court at this time?
I would like to tell the report that during that day, yes, we had a disagreement and everything about the key situation and the car. I reported the car as stolen, but I didn't tell the police officer to proceed with the charges of no domestic charge and everything. I did not tell the police officer to put that on the charge and everything. I just told him to report the car to proceed with the car stolen and everything else. And that's when they gave him an hour to come back. He didn't come back, and that's when they said they was going to proceed with it, the car being stolen.
Okay, all right. All right, anything further from the state of defense at this time? I do want to clarify, I apologize. Ms.Illette, what were the 2 prior arrests?
They were driving with a suspended license.
Okay.
Both of them, Your Honor.
Okay. All right, at this time, the defendant will receive a $7,500 signature bond through pre-trial. I'm sorry, Ms. Williams, will you turn your camera back on? I need to clarify, do you wish to have contact with the defendant?
Yes, ma'am.
All right. All right, anything further from state of defense before I rule?
Nothing
Your Honor,
further, Your
just
Honor.
Okay.
on the record, we just the state wants to object to
A signature bond, I'm sure.
the signature bond, but most importantly, the contact, because we just don't want anything like this to happen again, but we just want to put it on the record. Thank you.
Okay. Thank you. All right, defendant's going to receive a $7,500 signature bond through pretrial services per judge. 500 count 1, 2. 5,000 count 1 and 2,500 count 2. He's to take the 1-day anger awareness course and have no further violent contact with the alleged victim, in this case, last name Williams, and he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Your Honor, I apologize. I just I did want to add the stay away from the incident location if possible, because that was her mother's home and that's where he took the car. He took her car. And that was the basis of their dispute.
They don't live at that address, correct?
That was my understanding from the defense, Your Honor.
Okay. All right, I will add the stay away. That's reasonable. So he must stay away from 2050 Bent Creek Way at this time.
Thank you, Your Honor.
All right. Anything further? Best of luck to you, Mr. Williams. Who do we have next?
Position 11, Theodore Williams.
All right, Mr. Theodore Williams, your case is 23 CR 00074. I'm sorry, 00074C. In this case, you're charged with criminal trespass, Mr. Williams, with the offense date of January the 5th. Do you understand your rights?
Say it again.
All right, he says yes. Ms. Bostic.
Judge, in regards to Mr. Williams' 13 prior arrests, 1 FTA and 2001 arrest for probation violation. Judge, this defendant was just put on probation 12/20/2022 for 12 months for a criminal trespass at the same location, was told to stay away from 398 Parkway Drive. Nothing further.
All right, thank you, Ms. Bostic. Ms. Salette.
Yes, Your Honor. On January 5th, 2023, this found sleeping in the stairwell of that 398 Parkway Drive location that is a Bedford Pines apartment complex.
Yeah.
The defendant had previously been trespassed at that location on December 6th of 2022. As you heard from pretrial, he is currently on probation and it was ordered to stay away from that very location. I also heard a FTA, a previous FTA as well. So at this time, the state is going to be recommending that the bond remain the same at $2,000 surety bond and stay away from Bedford Pines apartments, no alcohol, drugs, or weapons while out on bond. Nothing further from the state at this time.
Okay, thank you. Ms. Thomas.
Thank you, Your Honor. Mr. Williams is 73 years of age. He is a lifelong Georgia resident. He does not have any family in the Atlanta area, but he did say he does have a sister in the Fort Valley area. However, they do not have direct communication. Mr. Williams stated that he has been retired for the past 5 or 6 years. He previously worked at Publix. Mr. Williams also said that he's recently suffered a physical injury to his femur bone that limits his walking. He stated that in the stressful situation, he does use the bus, and sometimes he uses the bus in that area come rain or when he needs a rest from walking. He does sometimes rest in the building. However, he stated that he understands that he can no longer go to that apartment complex and is asking for mercy on the court to be allowed to receive a signature bond or a bond no more than $500. Given that he only receives, I want to say SSI, about $800 a month, but right now he doesn't have his card and is being sent a new card. He doesn't have anyone else that will be able to assist him with making bonds, and currently will not be able to afford a high bond amount. Given this is a nonviolent offense, Your Honor, we are asking for, again, a signature bond or a bond no more than $500 to allow Mr. Williams the opportunity to perhaps bond out, or maybe if he can get in contact with his family member to assist him at this
Does
time.
he have a stable address?
He does. He gave me the he does have a stable address, Your Honor. He gave me his address, updated address, which he'll probably have to update with the clerk if and when he's able to be released.
All right, Mr. Williams, this is your absolute last opportunity. I do not want you to go back to that Bedford Pines address. Do you understand that?
Absolutely.
You don't even look at it. Don't cross the street. Don't even go down that road. You understand that, Mr. Williams?
I've gotten out of that area.
All right, Mr. Williams is going to receive an $8,000 signature bond through the jail. He is to absolutely stay away from 398 Bedford Pines, 1,000 yards in either direction. He's to have no alcohol, drugs, or weapons as a condition. Is
Thank
there
you.
anything further?
Nothing further.
All right. Best of luck to you, Mr.
Thank
Williams.
you, sir.
All right. Who do we have next?
Position 7, Posey. Posey.
All right. Good afternoon, Mr. Posey. Your case is 23 CR 00078C. You're charged with criminal trespass with the offense date of January the 5th. You understand your rights?
Yes, Judge, Madam Judge.
All right. Ms. Bostic.
Judge, I'm just going to admit I did not go through his complete history. He has an extensive arrest history. He has
Okay.
101
Okay.
arrests.
We don't need to explore 101. Did you perhaps see anything violent in the last 5 years?
No, Judge.
All right, that's what I need to know. Thank you. Ms. Salat, please proceed.
Yes, Your Honor. On January 5th, 2023, this defendant was located at a college park, MARTA, after previously being criminal trespass from the location. His suspension is from December 21st, 2022 until February 19th, 2023. At this time, due to him, although his history is lengthy, I believe the last arrest was from 2014. The state is going to be recommending a $3,000 signature bond on this case. No alcohol, drugs, or weapons while out on bond, and adhere to any
MARTA
suspensions. And as stated before, the one that's currently in place ends on February 19th, 2023, just in case Mr. Posey wasn't aware.
All right. Is there any objection from the defense, Ms. Thomas?
No objection from the defense, Your Honor.
All right. Defendant will receive a $3,000 SOB to the jail. At this time, he is to comply with the active MARTA suspension, which ends in February of 2023. He's to have no alcohol, drugs, or weapons. You understand that, Mr. Posey? Don't go back to MARTA.
Okay, am I getting a signature bond?
You're getting a signature bond.
How
All
long-
right.
How long would it take?
Now, I can't tell you how quickly you'll get out, but this case is no longer holding you in. Okay.
Okay, thank
All
you.
right. All right. Best of luck to you. Who do we have next?
Position 6, Page.
Okay. Good afternoon, Mr. Page. Your case is 23 CR 00007G. I'm sorry, 77G. You're charged with simple battery family violence with the offense date of November the 23rd of 2022. You understand your rights?
Yes.
All right. Ms. Bostic, can I have the history?
Judge, in regards to Mr. Page, he has an open felony case, 19 SC 173336, theft by taking, driving, possession of an open container, driving without a valid license. He also has another open case, and it appears to be the same victim, 22 CR 0085116G. And he was to stay away from her and 380 Martin Street.
All right. Thank you, Ms.
Even though the
Bostic.
name is listed as Karen Dennis in that one, but I believe it's still the same
Same
Karen.
person. Okay. Thank you, Ms. Bostic. Ms. Salat.
Yes, Your Honor. On November 23rd, 2020, the defendant and the victim in this case, Karen Dennis, they were dating, but at the time they were broken up. Ms. Dennis allowed the defendant to return to the home and get his belongings. When she asked him to hurry up, he became upset and struck her in the head and grabbed her neck. Ms. Dennis was able to break free and get help from a neighbor. As stated before, Your Honor, the defendant did have a previous incident with this victim in August of 2022. So maybe about 3 months before this incident, where he struck her in the eye, giving her a black eye and a blood clot in her eye socket. So although he was just given bond order in December for that case to stay away and have no contact with this victim, we would argue that he has shown a pattern of violence against this victim, as having two violent arrests against her in a matter of months. The state would be requesting a $5,000 surety bond, no contact with the victim, stay away from the incident location, and no alcohol, drugs, or weapons The incident location in this case before us today is that same 380 Martin Street, address unit 908. The state would argue that he poses a risk of reoffending, especially against this victim, and he's a danger to the community. Nothing further at this time.
All right, I believe the name was Dennis. I'm sounding for Miss Karen Dennis. Is that correct? Was that the correct name?
Yes, Your Honor.
All right. Ms. Dennis, if you are on this conference and wish to be heard. All right, hearing none, Ms. Thomas.
Thank you, Your Honor. And just to clarify, I believe it's my understanding that, yes, Mr. Page has a pending case involving Ms. Dennis, and I think while in custody, this now charge in front of us today was added. So it's not like he was out of, bonded out, got out of custody, then committed some alleged new offense, and then is rearrested. This was added on. I discussed briefly with Mr. Page. We have no problem with the no further contact and stay away. I do not believe they have had any other communications. Mr. Page is 53 years of age. He is a lifelong Georgia resident. He is a father of 2 twin girls, both adults. He was previously employed at Dots Automotive, where he has been working for the past 7 years as a mechanic. Right now, Mr. Page expressed that he is likely no longer working. He currently has a $3,000 surety bond. He doesn't have any financial assistance and is unsure that his daughters will be able to assist him with making bonds. Given that he's likely ineligible for a signature bond, I am asking for a bond amount no more than 1,000. I don't believe Mr. Page is going to be able to make bonds at this time.
The current bond is 3,000.
He has a $3,000 bond, surety bond on the
Other case.
case that he went to, I want to say in December.
Okay. All right. Thank you, Ms. Thomas. At this time, defendant will receive a $2,500 surety bond. He's to have no contact with the alleged victim in this case and stay away from the location on Martin Street. And he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further. Thank you, Your Honor.
All right. Best of luck to you, Mr. Page. Who do we have next?
Position 3, Gooden.
All right, good afternoon, Mr. Gooden. Your case 23 CR 0000073C. You're charged with simple battery with the offense date of January the 4th. Do you understand your rights?
Yes, ma'am.
All right, thank you. Ms. Boxton.
Mr. Robert Gooden has no prior arrest, Judge.
All right, thank you. All right, Ms. Salat.
Yes, Your Honor. On January 4th, 2023, at 30 Alabama Street, I believe it's near 5 Points MARTA station. The victim in this case, Trenton Boone, stated that he was waiting for the northbound MARTA train when the defendant attacked him from behind, punching him in the back of the head. A stranger ended up breaking up the fight between the two. The incident was caught on camera and officers were able to view that footage. Both the defendant and the victim attend Phoenix Academy School, and the defendant was positively identified from the camera footage by Atlantic Public School Officer White. The state is aware that this defendant does not have any prior history, so thus the state would be requesting or recommending a $5,000 signature bond through pretrial. A co-signer would be needed, no further contact with the victim, Trenton Boone, stay away from the 5 Points MARTA station, 9 p.m. to 6 a.m. curfew, and no alcohol, drugs, or weapons. Nothing further from the state at this time.
All right. All right, Ms. Thomas, I'm sorry, Ms. Gant, do you object to the state's recommendation for a signature bond through pretrial? I'm inclined to accept the state's recommendation and add the 1-day anger awareness course.
No objection, Your Honor. However, I would ask that the contact be amended to no violent contact. Mr. Gooden informs me that he and Mr. Boone actually are in a class together, at Phoenix Academy. And I would just ask the court to take this into consideration so that Mr. Gooden may continue attending school. He is in 12th grade. This is his final year. And his mother is willing to co-sign. Her name is Hazel Smith.
Okay. I'm inclined for them to have no contact. And I'm not sure how the school could work that out. Perhaps they can be in that class and be spaced such, and once the class is over, he can walk in the other direction of the alleged victim. Mr. Gooden, I know you want to say something, but I don't want you to interfere with your right to remain silent. If you have a very limited question, the court will hear it at this time.
Your Honor, if I may, Mr. Gooden, I do not want you to speak. My client did inform me that there is the possibility that he may be able to attend class virtually. However, I explained to him that that is not the court's decision to make.
Right. I would not be able to make that. What I'm going to do is the no contact will remain in place as requested by the state. Should he need to take that one class, I believe that there are ways, if they're in class together, they're not having direct contact, they might be in the same place. So he would be allowed to attend that one class, but if he sees Mr. Boone, I'm sorry, is that the gentleman's name? Yes, Mr. Boone, and the hallway defendants to go the other way and not even to speak to him, not to speak to him through a third party, and not to contact him via social media. So is there anything further? The order of the court will be that he's going to receive a $5,000 signature bond through pretrial services. He's going to take the 1-day anger awareness course. He's going to stay away from the 5 Points MARTA station. He's going to have the curfew from 9 p.m. to 6 a.m. He's to have no further contact with Mr. Boone, with the exception of the one class that they may have together. He's not to speak to Mr. Boone in class or even look at Mr. Boone in class. And he's not to contact Mr. Boone through any third party means. Is there anything further?
Nothing from the defense. Thank you, Your Honor.
All right. Best of luck to you, Mr. Gooden. If you have other questions, please give Ms. Gant a call. Ms. Gant's able to assist you. All right.
Yes, ma'am.
I'm sorry,
All right.
what was the bond amount?
5,000 SOB through pretrial.
Thank you. Position 1, Coney.
All right. Good afternoon, Mr. Coney. Your case is 23 CR 000076F. In this case, you're charged with 2 counts of battery family violence with the offense date of November the 26th. Do you understand your rights?
Yes, ma'am.
All right, Ms. Bostic, if I got these 3, please.
In regards to Mr. Coney, 10 prior arrests, total 7 in Georgia, 3 in Florida. 2 arrests for parole violation, 1 for probation violation. His convictions are more than 10 years old. There's been 2 for violence, though, a robbery in 2011 and an aggravated assault in 2011. Nothing further.
All right, thank you. Ms. Salat?
Yes, Your Honor. On November 26, 2022, the defendant was in his vehicle driving with his then girlfriend at the time, the victim in this case, Miss Alexis Presley. That's spelled EXIS, Presley, PRESSLEY. When they stopped at a gas station located in Atlanta, the defendant exited the vehicle, went inside the store, and returned with another, entered the car with him. Ms. Presley became upset, asking her to get out of the vehicle. A verbal altercation ensued. The defendant proceeded to grab all of the victim's belongings, including her phone, debit card, and other personal items. He then struck the victim multiple times, leaving visible injuries, and then kicked her out of the car as he was driving off. She had to ask someone at a nearby business to use their phone in order to get assistance because he had taken everything from her. The defendant has been arrested since it looks like, I guess on yesterday, but he has already called the victim while he's been incarcerated. And that 2011 aggravated assault He was sentenced to 13 years. And so he actually just recently got out of prison for that aggravated assault charge. That's why it seems like it's remote. But as soon as he got out, he committed another violent act. And so due to his violent history and him picking up a new violent charge against this victim, him contacting her already while he's incarcerated, the state would argue that he shows a risk of reoffending. He also shows a risk of intimidating witnesses while already trying to have contact with her in regards to this case. The state's recommendation at this time is going to be a $10,000 surety bond in total, $5,000 on each charge, no contact with the victim, stay away, stay away.
I'm sorry, Ms. Soleil, give me those amounts again. The computer did something strange as you were saying them.
Yes, Your Honor, it's $10,000 in total, $5,000 on each charge. The victim also wanted us to add a stay away from her where she's currently residing. She said that the defendant does know her current address, and that's 201 MacBee Place in Dallas, Georgia, 30132. The victim has stated that the defendant is very violent and she is afraid of him. And I believe she may be on the call, Your Honor, if you would like to sound for her when appropriate. Nothing further at this time.
All right, I saw Ms. Presley earlier. Ms. Presley, if you wish to make a statement, I would just need you to turn on your camera and unmute your screen. You're not required to make a statement, however.
No, I don't have anything to say.
Okay, thank you. All right, Ms. Gant, please proceed.
Thank you, Your Honor. Mr. Freddie Coney is 39 years old. He informs me that he has been in the Atlanta, Georgia area for about 6 months. He informed me that he was released in December of 2021, and I guess not December 2022. Mr. Coney has a 6-month-old that he shares with the complaining witness, Ms. Presley. He also has a 21-year-old son and additional family members in the Atlanta, Georgia area. Mr. Coney earned a GED and he is currently employed at Swade & Sons as an assemblyman and a quality assurance technician. He has been in that position for about 5 months. My client strongly denies the allegations and he is presumed innocent. He states that he was actually attacked back in August of 2022.
I have something to say. Hello?
Well, no, Ms. Presley. Continue, Ms. Gant.
States that he was actually attacked by Ms. Presley back in August of 2022 in Paulding County. And I would also just bring to the court's attention, just in reviewing the warrant, I understand that there is some video footage, but there, from what I read, is no evidence of my client pushing Ms. Presley out of a car. Mr. Coney, yes, while I do acknowledge his history, the offenses, aggravated assault, are quite remote, 2011 for robbery and aggravated assault. I am requesting a signature bond on Mr. Coney's behalf, and if Your Honor determines that he is ineligible, then I would ask for a bond of no more than $2,000, and that would be $1,000 for each offense. Regarding the state's contention that my client will intimidate and or reoffend, my client does not wish to have any contact with Ms. Presley. However, we are, Your Honor, requesting third-party transfer so that he may continue to see his child. And finally, Your Honor, regarding my client contacting Ms. Presley at this time, Your Honor, there is no stay away or no contact order in place. The state is not contending that my client has intimidated Ms. Presley at all. So I would ask that Your Honor not hold the state's contentions against him. In closing, we're requesting a signature bond or bond of no more than $2,000. We are unopposed to any no contact and stay away orders. We are requesting third-party transfer. And if Your Honor determines that he's ineligible for the signature bond, we would ask for a more reasonable bond, no more than $2,000, $1,000 for each offense. Thank you, Your Honor.
All right, Ms. Presley, would you like to make a statement? All right. Hearing none. At this time, defendant will receive a $6,000 surety bond, $3,000 on each count. He's to have no contact with the alleged victim, last name Presley, and stay away from the address in Dallas, Georgia. He's to have no alcohol, drugs, or weapons as a condition. How old is the child?
6 months, Your Honor.
I believe that's going to be the end of my ruling. I'm not going to order third-party transfer at this time. Third-party transfer can be revisited at the SAP calendar on the 20th.
Okay, hello.
Okay, Ms. Presley, you want to make a statement?
Yes, I have.
Wait a minute. Are you in a store? You cannot make a statement while in the store. You have to go.
Okay, just give me a couple. Can you give me a couple seconds? I won't say nothing. Just let me step outside.
Your Honor, the defense objects to any testimony from Ms. Presley. Your Honor has ruled, and I think that what's most important here is that there is a no contact and stay away order.
Oh, I want to clarify if she wishes to have contact. Ms. Presley, we do not have time. The court does not have time to wait. Are you checking out?
Yes, I'm checking out now. I'm done.
Okay, Miss Presley, the court has other cases to get to.
Okay.
We've
Thank you.
concluded this case, all right? If
Okay.
you have a question, please speak to his attorney. All right,
Okay.
best of luck to you, Mr. Coney. All right, who do we have next?
Position 9.
This is Kayla Weathers. Has
Yes,
has Miss Weathers heard her rights?
You ready, right? Yes.
She was on the screen. Okay. Miss Weathers, your case is 23 CR 00068Y. In this case, you're charged with theft by shoplifting with the offense date of December the 12th of 2022. Do you understand your right? Your rights are you have a right to remain silent. You have a right to an attorney. You understand that?
Yes, ma'am.
All right, Ms. Bostic.
5 prior arrests, 1 conviction for disorderly conduct in 2012, 1 arrest for probation violation. Currently has an open case in Fulton County, 23 CP 215210. Possession of a Schedule II drug-related drugs not in original container. Nothing further.
All right, thank you, Ms. Select.
Yes, Your Honor. On December 12, 2022, Officer Patel was flagged down by a Zabian Wooten, loss prevention officer at a Walmart at 5200 Windward Parkway in Milton. Mr. Wooten advised that he was conducting video surveillance when he observed a female wearing a white shirt and blue pants pick up a hoverboard and a Shark robot vacuum and placed them into her shopping cart. He said that the female then walked towards the self-checkout area and crossed all point of sales. He then stated that the female had no intention of paying for the items. She left out of the store and drove off in a red Chevrolet Cruze. The loss prevention officer was also able to get the tag number as well. The tag number did return back to being registered to the defendant, and the GCIC provided a picture which the officer was able to match with the video and the picture that the loss prevention officer had of the defendant stealing from the Walmart on that day. The state's recommendation at this time is going to be a $1,000 surety bond, stay away from that incident location, no alcohol, drugs, or weapons. She does have some history as recent as January 2022, about a year ago, a simple battery family violence arrest. She has a previous probation violation, a driving without a license being suspended, which she did plead nolo to, and also a disorderly conduct conviction from 2011. The state would just argue that she does pose a risk of reoffending due to her history. Nothing further at this time, Your Honor.
Thank you. Ms. Thomas?
Thank you, Your Honor. Ms. Weathers does strongly deny these allegations. Your Honor, Ms. Weathers is 30 years of age. She is a lifelong Georgia resident. She is a proud mother of 6 children. They're currently with their dad at this time. Ms. Weathers obtained her paralegal certification and has attended some college. Ms. Weathers is also employed. She is working at the Weaver Law Firm in Cummings, Georgia, as a paralegal, where she's been working there for the past 2 years, Your Honor. I would be requesting a signature bond on Ms. Weathers' behalf, and if the court is not inclined on granting a signature bond, then a bond no more than $500 at this time.
All right, defendant will receive $1,000 signature bond through the jail. She's to stay away from that Walmart on Windward Parkway and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. Thank you.
All right, best of luck to you, Ms. Weathers. Who do we have next?
Position 4.
All right, good afternoon. Your case is 23 CR 00075F. In this case, you're charged with battery family violence with the offense date of January the 5th. You understand your rights? Is that a yes? You can nod yes. You understand your rights?
Yes,
All
ma'am.
right, thank you. Ms. Bostic?
Judge, what's the defendant's name?
Pronounce it for me. It's Johnson, position 4.
Johnson? No prior arrest, Judge.
All right, first arrest. All right, Ms. Salette?
Yes, Your Honor. On January 5th, 2023, officers responded to 61 Peyton Place in Atlanta. Officers met with a Miss Jemiah Thomas, who stated that her sister, who was the defendant, they live with their mother, Miss Brandy Myers, who is the victim in this case. That's spelled Brandi Myers, Myers. And Miss Thomas stated that she overheard an argument between the defendant and their mother, Miss Myers. She then stated that she saw the defendant strike their mother in the face, leaving a scratch on the mother's left eye, which was visible to officers. Due to the defendant not having any criminal history at this time, the state would be recommending a $5,000 signature bond. In pretrial, a co-signer would be needed. No further contact with the victim in this case, Brandy Myers. Stay away from the incident location, 9 p.m. to 6 a.m. curfew, and no alcohol, drugs, or weapons. We do understand that this is a mother-daughter relationship as far as contact is concerned, but this incident did just happen on yesterday, and we just want to make sure that there is a significant cooling off period. Nothing further at this time, Your Honor.
All right, I'm sounding for Ms. Myers. I believe I see her on the screen. Ms. Myers, if you would like to make a statement, you're not required to do so, but if you'd like to, this is your opportunity.
Yes, ma'am.
Okay, before you speak, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, what would you like to tell us at this time?
I don't want to press charges against her. Like the lady just said, it's a mother-daughter relationship. I just want Tanaja to respect me and my household. She is a mother of a 6-month-old.
So you wish for her to return to your home and have
Yes, ma'am,
contact with you?
with stipulations of she's not to become violent or act as if she's gonna become violent.
All right. All right, thank you. I appreciate you coming to court, Ms. Myers. Ms.
Yes, ma'am.
Gant?
Yes, Your Honor. Ms. Tanaja Johnson is 18 years old. She states that she has been in the Atlanta, Georgia area since the 6th grade. She, again, as we heard, is the mother of a 6-month-old. She completed high school, and one day she plans to join the Army. Ms. Johnson is unemployed. She has been so for about a month. She states that she was scheduled for a job interview at Amazon. She denies the allegations. She is presumed innocent, Your Honor. I am unopposed to the state's recommendation for a $5,000 signature bond. I did speak to Ms. Johnson's stepfather about co-signing. However, Your Honor, she is 18 with a 6-month-old. I am opposed to the no contact and the stay away orders. I would ask that this court grant a no violent contact order. My client is 18, unemployed with a minor child. She will not be able to secure another residence. And lastly, Your Honor, we are opposed to the curfew. She has, again, a child that may need to be taken out of the house for medical needs. And of course, my client is seeking employment. And we certainly do not want her options limited with the curfew, Your Honor. Thank you.
All right.
Your Honor,
Judge, we do not require I'm sorry, this is Ms. Boss. We do not require the curfew. This is not needed. It's not like it happened late at hours. The no further contact. And
I'm inclined to grant the curfew, honestly, Ms. Bostic, but I will hear from pretrial. I know that may not be typically done. I just want to make sure that it's clear to the defendant that the seriousness of this condition. But please continue, Ms. Bostic.
Well,
And then
also,
I'll let Ms. Salet finish.
normally the co-sign is done by the person she lived with, but it can't be done by the victim.
Okay, so Ms. Gant, other than the alleged victim, Ms. Myers, is there someone else available to co-sign the signature bond?
Yes, Your Honor. I informed the court that her father, Joshua Myers, is willing to co-sign.
He's willing to do it. Okay, I just wanted to
Yes, Your Honor.
clarify that point. All right, Ms. Salet, you had a point of contention.
yes, Your Honor. I just wanted to ask a couple of follow-up questions to Ms. Myers.
Very briefly, Ms. Salet.
Yes, ma'am, I'm here.
Go ahead.
Ms. Myers, did you speak with you spoke with Ms. Amon Cheney from the solicitor's office?
Earlier, yes, ma'am.
Yes, okay. And at that time, you told her that you did not want your daughter to come back to the home. You wanted her to get her belongings.
Yes, ma'am, I did. And I had to really sit back and think about the situation, because my only concern, she's 18, but all in all, we have to do what's best for that baby. Tanaja don't have anywhere to go. That means that baby don't have anywhere to go. So I really had to sit back and reevaluate this situation. Since
Do
I
you feel
spoke
that,
with,
Ms. Myers, do you feel like you'll be in danger if your daughter returns home?
no, I don't. I'm not. No, ma'am. No,
You're not afraid of her?
no, I'm not scared of her. I had her. No, ma'am.
Okay. I have to ask those questions.
Yes,
All right.
ma'am. But my thing is what's in best interest of that baby. And long as Tanaja can come back respectful, Tanaja, she doesn't pay any bills. Tanaja's up on my roof, okay? She
Thank
got to
you.
come back respectful. And I understand that respect goes both ways.
All right,
Thank
Ms.
you, Ms.
Salet.
Myers. I don't have any other questions, Your Honor. I just wanted to get that on the record that she did say to our office earlier that she did not want contact.
Okay.
But thank you.
All right, we're
Yes.
gonna to emphasize the seriousness of this. Ms. Johnson will receive a $5,000 signature bond through pretrial services. She's to take the 1-day anger awareness course and complete 20 hours of community service. She is to have no further violent contact with the alleged victim, in this case, last name Myers, understanding that is a point of grace by the court. She is to have no alcohol, drugs, or weapons. I'm going to employ the curfew unless she is attending work, school, training, or a medical emergency. All right. Is there anything further? Yes, Ms.
Yes.
Myers. Very
Yes, ma'am.
briefly.
Why do her bond got to be so high?
It's a signature bond. That means she does not pay it. You can speak with Ms. Gant regarding questions, but she's essentially someone's gonna sign her out. But should she reoffend, that bond would apply. Okay.
Yes, ma'am. Thank you.
All right. Best of luck to Ms. Johnson. We do not want to see you back here. Do you understand that? All right. Who do we have next?
Thank you, Your Honor.
Position 2, Davenport.
All right. Good afternoon, Mrs. Davenport. Your case is 23 CR 00071Y. In this case, you're charged with simple battery with the offense date of October the 2nd of 2022. Do you understand your rights?
Yes, ma'am.
All right, Ms. Fosdick?
Judge, in regards to Mr. Davenport, 2 prior arrests, conviction 2017, theft by shoplifting, and another arrest for probation violation in 2018. Nothing further.
All right, thank you. Ms. Select?
Yes, Your Honor. On October 2nd, 2022, the victim filed a report stating that the victim Shada Kanzater, that's spelled Shadacanzater, was driving her vehicle when her and the defendant got into an argument over music playing in the car. The victim stated that the defendant stopped playing the music, or asked the defendant to stop playing the music, and he didn't. The victim then asked her son, who was in the car, to give her some headphones to block out the music. The defendant called the victim a stupid B word. At that time, the defendant slapped the victim in the face. The victim did not appear to have any visible injuries. The parties involved in this case, they do live together, and at some point they were engaged. Although the defendant does not have any previous violent arrest or history, it appears, the state would be requesting a $2,500 surety bond, no further contact with the victim, no alcohol, drugs, or weapons. Due to the nature of the charges and what we know about the cycle of violence, the state would argue that the defendant does pose a risk of reoffending towards this victim in this case. Nothing further at this time.
All right, I'm sounding for the victim. I'm sorry, what was the last name again?
I believe Kanzater.
Okay, is the victim in this case on the line and wishes to make a statement?
Hi.
All right, do you wish to make a statement?
Yes.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do.
All right, what would you like to tell the court at this time?
I just want to say that was a situation that had never happened before. It kind of caught me off guard, and Mr. Davenport did agree to doing anger management classes in counseling, and stated that that would never happen. It wasn't something that, I guess I did my police report because it wasn't something that ever happened before, so it kind of caught me off guard.
All right, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Drayson Davenport is 27 years old. He has been in the Atlanta, Georgia area his entire life. He informs me that he has 2 children, ages 11 and 8. He does have a child support order for his son. He also states that his son lives with him. Mr. Davenport earned a high school diploma, and he is currently employed in construction as an independent contractor. My client denies the allegations. He's presumed innocent, and I believe from the warrant, it states that the complaining witness actually verbally insulted him by making disparaging comments about his mother. Your Honor, I did have the occasion to speak to Ms. Kanzater, and she informed me, as I believe she informed the court, that she wants to have contact along with my client. Therefore, Your Honor, in light of my client's absence of convictions for violence, I am requesting a signature bond on his behalf. I do acknowledge that he has some history. However, it appears that his last arrest was in 2018. He's never been again arrested for any violence, so we do not believe that the state's contention regarding reoffending or intimidating witnesses is valid. I would ask the court for a no violent contact order, Your Honor, and the signature bond. Thank you.
All right. At this time, defendant will receive a $5,000 signature bond per judge through pretrial services. He's to take the 1-day anger awareness course and have no further violent contact with the alleged victim in this case. Moreover, he is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Yes, Your Honor. Just briefly, Miss, I just needed to make an announcement to Miss Shada. I sent her a message in the chat, and I was just hoping that she could respond before she leaves the Zoom for the day.
Do you want to tell the court the nature of the message, or?
I was just
Or
asking
she
for the
just-
phone number.
Okay, that's fine. Miss Kanzader, if you would please give your information to ASG Select, we would appreciate it before you log
Yes,
off.
I
of
just
this
seen
Zoom.
it.
She
I
just
I
sent it,
seen
Your
it.
Honor. Thank you so much.
Okay, perfect. Thank you. I just wanted to clarify. All right, the only position we have remaining is position 8. Is 8 going to be reset, or will we be addressing that position today?
Position 8, Judge, let me check to see who that is.
Robinson, the one that Ms. Thomas has not had a chance to interview.
Yes, she's in ABCD, that stands for Union City.
Okay,
Well, Your Honor, if she's there, I haven't had a chance. I'll ask for a reset because it sounds like there may be a MH or a behavioral issue. And I'll just request one of our social workers to go down there to
Okay.
do an evaluation.
I want to make sure, is it being reset medical? Because if not, we may have an issue. If it's a medical reset, we're okay with
Okay.
Riverside. If not, if it's just, I just want to make sure, is it a medical reset? Okay. All right, hearing that it's a medical
Yes,
reset.
it's a medical reset, Judge. I'm sorry.
Okay, thank you. I just want to clarify that point. Hearing that it's a
Thank you.
medical reset, we have completed the entire calendar. Courtroom 2 and 3 can be excused. And Ms. Grace, will you please review the calendar for me?
Yes, Judge. Position number 1, $6,000 good bond. Position number 2 is a $5,000 pretrial bond per judge. Position number 3 is a $5,000 pretrial bond. Position number 4 is a $5,000 pretrial bond. Position number 5 is a $2,500 good bond. Position number 6, oh my goodness, I didn't even write that on my paperwork. Just one moment, please. Position number 6 is a $2,500 good bond. Position number 7 is a $3,000 saddle bond through the jail. Position number 8 is reset 1723 SCA calendar. Position number 9 is a $1,000 saddle bond through the jail. Position number 10, $7,500 pretrial bond. Position 11 is an $8,000 saddle bond through the jail. Any questions, comments, or concerns?
Miss Grace, are we sure that the reset date for SAP is January 20th? I think that's a Friday.
It's 119. It was corrected by Ms. Champion, yes.
Oh, okay. Sorry. Thank you.
That's okay.
All right, any other comments, changes, corrections, or questions? All right, hearing none, we'll be in recess until tomorrow's SCA calendar. Everyone take care. Have a great rest of your weekend. Bye-bye.
Yeah.
Thank you, Judge. Have a good one.
Bye-bye.